all types of things. Any type of possible abuse, that's what we are seeing and more prevalent with our aging population. Today I wanted to talk about preparing the case for prosecution. I'm a prosecutor, and I know we have a varied audience today. We have some law enforcement, we have some elder law attorneys, we have APS workers, people from the Secretary of State's office, and many of you are going to be involved with the prosecution of elder abuse cases. So I wanted to tell you a little bit about what we do as prosecutors, and so you know where we're coming from, and then give you some suggestions about things that you can do that will help out with the prosecution, so hopefully we can have more successful prosecutions. So we're going to start from the beginning to the end, and a case never really ends, and we're going to talk about that a little bit as well. Here's our objectives for today. We want to know who are the players, who is here, who takes part in the prosecution besides just the prosecutor. What do I think about when I'm a prosecutor? What do I have to consider when I'm making, I know you've all heard of plea bargaining. Do I take something to trial? Do we give them an offer? Do I not give them an offer? So you can see where I'm coming from that, and maybe help you better understand why some cases have the outcomes that they do. We're briefly going to go over the court process. I think most of you should be familiar with that, but if you don't come into court very often, we're going to touch on that a little bit. And then I just want you to know, again, just understand that the prosecution never really ends. After the trial, there are appeals, and then things can come back, and it just goes on and on. Okay, so how does the criminal justice system work? Let's start with that. We're talking about the criminal justice system here, not the civil sphere. And so it's just focusing on criminal justice. So we have the prosecutor, we have our victim, we have our advocates, our witnesses, our officers. These are the people. So who are you? I touched on that a little bit about you are here because you have an interest in specifically elder abuse cases and hopefully elder abuse prosecution. We have another big player that I always have to make sure that we're considering is the victim as well. We don't want to lose the victim, they need to be the focus of our entire prosecutions and everything that we're doing. It is for them. How do I get a case? Where does it come from? Here in Forsyth County, we have an elder abuse task force, and it has members of the APS, has law enforcement, some ombudsmen come, the district attorney's office has representatives. Occasionally we'll have the county attorney, the clerks of court, we've had doctors come, I'm just trying to think of some other people that have participated before in that task force. Generally it's the people that you see listed up there, but occasionally we'll have other people that will have something arise that they want to talk with. And it tends to make things a lot easier when you have a group of people. So when I'm in the elder abuse task force meeting, the APS will bring all their different cases, or law enforcement will bring their different cases, and we'll talk with each other, and we'll, even before a case comes to me, we'll start talking about it and discussing it at the elder abuse task force. And I can give suggestions, or other people can give suggestions. It's a great way for our law enforcement to link up with APS and get contacts and make connections. People may call 911, they may call the non-emergency number. People are going to be reporting abuse situations to law enforcement. That's where I get most of my cases. We, in my office, have an on-call phone. It is available 24/7 for the law enforcement in our county to call and get in touch with a district attorney and ask them questions about a case, whether it's consulting on charges, or if it's about, just questions with the investigation or things they may need to know. And we'll get a lot of our cases that way as well. Also, APS referrals. APS has to turn in their referral forms to the law enforcement officers, and also we get a copy of it here. I review those when they come in, and if they have substantiated, unsubstantiated claims of abuse, I make sure that those are being followed up on. I have multiple times private attorneys contact me with cases. I just had one last week where some type of civil lawsuit will start, and then the private attorney will contact me and we'll talk about it. I then will lead them to law enforcement or direct them to a particular officer sometimes to follow up and see if their case that they have has some criminal elements, and if that's something we can follow up on. The investigation, though, is always done 100% by law enforcement. The district attorney's office and I don't go out, we don't investigate crimes ourselves. Everything we get comes from a law enforcement officer. So the officers are going to investigate the allegations. They're going to gather up the evidence. They are going to consult with our office, whether it's in person. I have them come and meet with me in person oftentimes, or whether they're calling that phone. Law enforcement are going to be the individual for making their arrest. Then they're going to write their report, and then I get the report. So the first time that I'm really delving into a case, other than the times where I've met with people previously, but when it's assigned to me is when I get that report and it comes into the office. So then it comes on my desk and I'll just have a blank report. It will have whatever the charges have been decided. A lot of times in elder abuse cases, we have specific statutes for abuse and neglect, but oftentimes if it's a financial form of abuse, it may be obtaining property by false pretenses, it may be larcenies, it could be anything along those lines that are also going to touch on the older population and be considered an elder abuse case. So what is my job? Once I get these reports, what is my job as the prosecutor? My job is to do justice. I have to, people don't usually think about this, but part of my job is to protect the rights of the defendant, make sure that the system is treating them correctly and fairly. When I first report, I read the reports, I examine charges. My job is to make plea offers. About, I don't know, probably like 98% of my cases are settled by plea, and that only about 2% or less will end up going to actual trial. So a lot of plea offers get made. Then to try the case, that's my job. And in all of those, I need to keep my focus on my job is to do justice. But what is justice? Justice isn't the same thing for every case. It's very case specific. So sometimes justice is dismissing the case. I've had cases where I've looked at it and the right thing to do was actually to just dismiss the case. Sometimes it's throwing the book at somebody. Sometimes it's going full barrels, just trying to get somebody locked up and taken out of society. Sometimes that is justice. And oftentimes it's somewhere in between. So when I look at a case and I'm trying to determine what offers I'm going to be making, then I need to consider what is justice for this particular case. So I'm looking at the case. And when I first get a case, what my focus is can I prove it? Can I prove this case? Officers have one standard that they look at. Their standard is the probable cause standard. That's just, is it more likely than not that a crime was committed, and did this individual commit this crime? That's probable cause. Is it more likely than not that this person did it? My standard is proof beyond a reasonable doubt, and that's a lot heavier standard. Is it more likely or not, or proof beyond a reasonable doubt, which is the highest standard that we have? So sometimes my officers will take out a case and the probable cause is there. Is it more likely than not? But it's not too beyond a reasonable doubt. So sometimes there's a difference there in the allegations and what I can prove. So when I am reading a case, I have to look and see, what can I prove in this case? Oftentimes I agree with my officers. I'm like, yeah, I think this guy did it, or this girl, but can I prove it? Can I prove it? And that's what I'm thinking of as the prosecutor when I'm looking at something. Sometimes if I think that my level of proof is not quite there yet, or if I'm missing something, if I need a little more, sometimes I have to direct my officers to go back and they have to do some more investigation, or interview particular witnesses, perhaps get a video if they exist, surveillance videos, things like that, pull medical records, pull phone records, anything I can do to bolster the evidence that I have so that I can meet that very high standard of proof beyond a reasonable doubt. Do I have the evidence? Do I have a way to get evidence in at trial? Even if I have the evidence, it doesn't mean it necessarily comes in at trial. It's very frustrating sometimes when you have to prove a chain of custody. Do I have the witnesses? Do I have a person who can testify to this particular piece of evidence? Can I get it in? Is it hearsay? Is it something that's going to be excluded? Is it overly prejudicial? These are all types of things that can be legitimate, good evidence for me, but that may not actually be admissible, or I'll have to find some way to get it in when the actual trial comes up. So that's another thing that I'm looking at. Just because I have evidence, is it evidence that I can use? So that's another thing that we have to consider. In the elder abuse cases specifically, one of the very first things that I look at is my victim competent to testify? Now, it's not necessary that the victim be competent. It's really helpful. But I put that little note on there, homicides are not tried with victim testimony. So clearly you can try a case without the victim testifying. But if I have an incompetent witness, someone who is not going to be able to get on the stand and is not going to be able to testify, I'm going to have to get in that same evidence in different ways. Most of the time when someone is a victim of a case, I would put my victim up and I would just ask them, did this happen to you? How did this happen? Who did this to you? What has it done to you? Things like that. But if I have someone who is suffering from dementia, who won't remember, if I have someone who, I've had an older adult witness before that was just so stressed out by the thought of coming to court and testifying. They were terrified. They were not going to be available to testify. I don't think it's my job to re-traumatize people that have already been through some very traumatic experience. So then I have to start thinking about those other ways to get in evidence. And that's one of those times where I might have to send my officers back out to do further investigation, because I'm not going to be able to have my victim testify. And so I'm going to have to get those documents, that evidence, the statements, anything that I can think of in a different way. In what way can I get those things in? It can be quite difficult sometimes, but I have to have the evidence to be able to go forward. So another thing that I look at is there a civil component? Now, this is one of the things that there's no notification, at least in my county, where if there's a guardianship procedure, if there's a power of attorney, that hearing that's going on, if there's something like that, I don't hear about that. Nobody comes and tells me, hey, Jessica, you have a criminal matter that's going on. Oh, by the way, there's also this guardianship proceeding. In our county, guardianship proceedings are recorded, which would be excellent evidence, because most of the time the defendant is testifying there, and I would like to be able to use their statements in my criminal trial. If you are a clerk or a civil attorney who's on, that's one of the things you can do that would help me, is just at least let me know that it's there. Let the police officers know, hey, you may want to tell the DA that there's this whole civil side that's occurring right now. We don't cross that line. We don't go over to the civil side. We stay clearly on the criminal side. So if there is something there, please tell us so that we know, so we can use that as part of our case and part of our investigation as well. Then another thing, again, when I'm looking at the case, I have to consider again, what is justice for this case? I talk with the victims. I want to know what does the victim want? As well as I do, that oftentimes the defendant for my case, it may be the abuser. The defendant may be somebody who's a care provider for my victim. And if the defendant is locked up and put away, then there is no care provider left for my victim, and they need somebody there to take care of them. And it is going to be a hard place for the victim. So I talk to my victims. What do you want? What do you want with this case? I had one one time where an older adult had a child with a disability. They had a mental disability, and they had attacked their parent, who was in his late 80s, and he was injured. And he told me he just wanted to dismiss the case. He came in to what we call our first appearances. We're going to talk about that here in a minute. And he said he just wanted to dismiss the case, and he wanted his son to come back home. And I told him that I wasn't going to do that. He was actually a care provider for his son. It wasn't the other way. But he didn't want his son locked up. He didn't want him incarcerated. He didn't want him prosecuted for something that he didn't necessarily have a lot of control over himself. So we ended up finding a housing situation for that defendant, a group home, someplace that in the long term may be a viable solution for that defendant, and not be a risk to my elderly victim. And I told him at that time that if it ended up working out, and if there was no more problems for 1 year, that I would dismiss the case. And that's one of the cases I ended up dismissing, the case against his son, who had assaulted him. So sometimes that is justice. Sometimes that is what we're trying to find, is just, I want to help my victim. I want to get justice for the victim and for the defendant. So that would be one of those times where, does this defendant have a special circumstance? This individual, he was competent to stand trial, but he did have a mental disability. And so I would consider that a special circumstance. So we handled that case in a different way. And it was very difficult for my victim when I first told him, no, I'm not dismissing this case right now. But when we talked through it, we found some resources and some abilities to protect him and to make a better outcome for his son for the future. So these are all things that I look at when I get a case. Going to trial, again, is not always the right answer. And so I'm trying to decide, what is justice for this particular case? When I look at a case, another thing I consider is, what were the outcomes of previous cases? What are the jurors in my county, what do they care about? What are they thinking? What is the outcome for this case going to be? If I go no plea offer and I go full barrel, am I still going to just get a misdemeanor conviction and a little slap on the wrist? If I do all those things, is this going to be the outcome? So that's a consideration that I have to make as a prosecutor with our limited court time. I use the outcome from previous cases. I compare them to the facts of the case that I have in front of me. I try to decide what is fair, what did I offer prior defendants with similar situations, so that I can be even across the board, and trying to treat people fairly as well. So that's another consideration that I have to think about. And then we come to the plea bargain. So again, most of the cases, we're going to make some type of offer. Occasionally, I'll get a case where there is no offer, and the only option is to plead straight guilty or go to trial. But most of the time, where there's some type of offer, where I will offer what we would consider a mitigating factor, that's something that is good on behalf of the defendant and would give them a slightly less sentence. Or I might consider aggravating factors. That's something bad that's for the defendant that would make it a higher sentence. Different things like that we're going to take in consideration. Would I change this crime that they're charged with to a different crime? Was that going to get them less time? Is it something that I can prove? These are all things we're going to think about in the plea bargain, plea offer. And again,
Pardon me, if I could interrupt you at this point where you're talking about plea bargains. Please share with our audience how restitution factors into that process or development of plea bargains.
Sure. Restitution is often really important to our victims of financial crimes. Also, if they have heavy medical records or medical bills, I should say, restitution tends to be a real factor. Oftentimes, if somebody has had their property stolen and it was something very sentimental, most of the time, sadly, we can't get those things back. Most of the time, if somebody has taken something, they've sold it, and jewelry often is quickly destroyed by pawn shops, things like that. restitution is a bargaining chip that I can use if somebody is willing to pay back the money up front and they have the ability to do that, then I could take that in consideration into what I would offer them or let them plead to, whether I would be pushing for active time or a probationary sentence. There's some other things we can do that are something called a conditional discharge, where for someone who doesn't have a record, this is maybe their first offense, if they can give me back all my money or the most of the money that I can possibly get, then I might be considered let them do something that gives them a chance to possibly get something off their record in the future. Most of my defendants don't have an ability to pay restitution. So my parents, their house was broken into, they had a bunch of cash stolen and other things like that. And I had to tell them the same thing that I tell a lot of other victims that I talk with, that expect nothing. And then if you get something, you'll be happy that you got something. So restitution is a tricky thing, but if somebody has the ability to get it and is willing to give it, a lot of times people will be willing to come up with some money to try to keep themselves from going to prison. And if my victim needs that money, then that's something that I'm definitely going to consider.
Jessica, what do you need from victims or from victim families in order to pursue restitution in a case?
I can't ask for restitution without some type of proof. Everybody whose car gets broken into had an iPad in their car. It's that kind of thing where something gets stolen. You're gonna have to have some type of documentation or proof. It's easy for me to prove when somebody has cleaned out somebody's bank account, because banks keep very good records. So my officers will have that. It's easy for me to prove if somebody went and bought a car with somebody else's money, because that's going to be an exact amount of money, or if they took a vacation with the money that they did. Things like that are going to be easy to show, but that's what I need. When in my office, we have a victim impact statement and a restitution form that we provide to our victims. It has to be filled out and then returned, and some type of proof of the value of things at the time they were taken. That's another thing people don't understand about restitution. If somebody takes your TV, then they got your TV and you have to go buy a brand new one. But restitution actually is for the value of your TV at the time that it was stolen. It is not the amount of money it's going to require to get a brand new TV. So that's a difficult thing for people to understand sometimes as well. But if I can prove, I have to be able to show the judge how much money we're asking for, and then I have to be able to show the judge why. So just any documentation, any photographs, anything like that that you can have to prove the estimate and value for restitution.
Jessica, can you address the situation where perhaps an elderly individual has entrusted a credit card or debit card to somebody in order to make essential purposes, and then that individual uses that credit card to make purchases for themselves?
Those are going to be harder to prove, because I have to prove that they didn't have consent for some things when we all know they did have consent for other things. Sometimes it's easy to prove. I've had one case like that before, where it's like groceries, power bill, porn, and it or tennis shoes not in the person's size or things like that. But this individual didn't go to those type of websites and spend money on that type of thing. So that type of thing is easy for me. It becomes harder when it's going to the ATM and they're taking out cash, and then they're using that cash for the groceries and for personal effects. So it becomes more difficult in those situations, and it's really going to rely on what the victim actually can tell me at that point in time, and what my officers can prove what the money was actually spent on. Now, another wrinkle in that is people will have the ability to give all their money away if they want to. As long as they're competent. If they're like, you know what, I just didn't care, they could have all the money they wanted, then it's going to be difficult for me to prove some type of abuse there, where they came in and they just kept taking money and money. Oftentimes this happens, and then one day all the money will be gone, and they'll be like, what? No, I didn't realize all the money was gone. But they've been consenting all along, and you have the ability to consent. And so that those kind of cases are going to be really difficult to prove when somebody comes up later and says, oh, wait, I didn't realize they took that much money. And it always is a slow trickle, but it ends up draining the entire account. So those cases are going to be really difficult to prove because of the consent issue.
Thank you, Jessica.
Sure. So I'm going back to plea offers and what I'm thinking about. Again, what is justice in the case in front of me? What am I considering? Again, sometimes it's that dismissal, sometimes it's going all out, and sometimes it's in between. So I'm considering that in the plea offers as well. So after I've made my offer, what happens next? And there's two types of courts that we might be handling something in. This is my brief overview of the courts, so I'm going to make it pretty brief since I think most of you should know. But we have the district court, which is the lower court, and the superior court, which is the higher court. Then, of course, we're going to talk a little bit about the Court of Appeals, the North Carolina Supreme Court, the U.S. Supreme Court, different types of courts that I myself will be involved in. There's also the whole federal system. They're going to have their own levels of courts as well. But just talking about the state system, the cases that I as a state prosecutor may be interacting in, the first one might be in a district court. If I have a misdemeanor case, it's going to be handled in the district court. If it's a trial, it's going to be tried by just a judge. In criminal trials, there's not going to be a jury in the district court. And then we'll handle misdemeanor pleas in the district courts. If it's a felony case, they're in our county, in Forsyth County, lower level felonies, H&I felonies, we can handle in the district court with pleas as well. But if it's a higher level felony or even an H&I, I can handle it in the superior court. We're going to have to send our charges to the grand jury. And once the grand jury comes back with a true bill, then it gets up into that superior court. And we're going to take pleas in superior court. And if we have a trial, the North Carolina Constitution was amended several years ago, where now you can have a trial just with a judge, what they would call a bench trial, or generally people choose to have a trial by jury. But now defendants do have a right in North Carolina to have a trial by bench trial in superior court now. So let's talk a little bit about the district court. On the first day after somebody's been arrested and charged, they're going to be given a court date, and then they have to show up on that court date. And the very first thing that happens when you show up on your court date is you're going to be asked, what do you want to do about a lawyer? Do you want to hire your own lawyer? Do you want the court to appoint you a lawyer, or do you want to represent yourself? So that's always what happens on that first court date. Very few times is somebody willing and ready to go ahead and take care of their case the very first time that it comes on. I put in here endless continuances. Everybody always thinks that things should, maybe everybody gets 3 or maybe everybody gets 4, but no, a lot of times there's no set number for continuances. Things can be continued forever and ever. Eventually though, somebody's going to have to stop continuing things, whether it's the judge who says no, or the DA who is holding the line, or the defendant who is really ready to go ahead and try their case. So it just depends. Continuances sometimes are for the defense, sometimes for the state. It also depends. It's not always one side. In cases involving older adults, it has been my experience where the defense often wants to continue things out for a very long time, especially if somebody has a health issue, because they are trying to wait for a person to pass, so that they think maybe the case will go away if I don't have a victim that can testify. That is a defense tactic that I've seen with cases involving older adults. So a lot of times they'll be continuing things ad nauseum, waiting for that to happen.
Is there a workaround to that, Jessica? If the defense is continuing the case or repeatedly asking for continuances, and you have good cause to believe it might be until the victim is no longer capable of testifying, what can be done?
I can fight their continuances. It's going to come down to the judge whether or not they grant the continuance. And I can say, I think that this is what they're waiting for. And I have said that before. And I'm like, no, we're ready to go. So then eventually the judge will hold the line. But if the defense attorney comes in and they're like, I have a health issue, or I have this, and they have a legitimate sounding excuse for the continuance, then oftentimes the judge will grant the continuance. So I don't consent to all the continuances, and that's how I fight that. That's when I come in and I'm like, we're ready, they had notice, everything has been done, we're here today, we're ready for trial. That's what I can do for the continuances.
Jessica, is there a mechanism in North Carolina to preserve the testimony of a witness who may become unavailable?
We would have to have a deposition done, which in criminal trials we don't do very often, but we can. But if we had a recorded sworn testimony, and the defense has to have an opportunity to cross-examine. So it would be like a little mini trial without the actual trial for a deposition to be done. For that, there's also exceptions for unavailability for certain statements that were then captured by the police and things like that, things that we can use to get around hearsay to be able to get some statements in, but the courts are going to keep that pretty limited. So if there was a situation with a serious case where I thought something like that might be happening, then I would be pushing to have my witness deposed so that we could save that and use that.
Jessica, we do have a question. Can you share some do's and don'ts for investigators or officers testifying, whether it be in district court or superior court or maybe even grand jury?
Sure. And I'm going to skip that for a minute because I'm going to come back to it. That's one of my slides in the future. So I am going to touch on that, but I'm going to touch on it here in just a little minute, if that's okay.
Sounds great.
Okay. So here we go for our district court. So we can have pleas or we can have trials. It's going to be a trial with the district court judge. And then in district court, cases can always be appealed. This touches a little bit on your last comment. And in district court, oftentimes the district court DA this is the first time they've seen a case. And they are trying it the very first time they've gotten it. They haven't had a chance to read it. They hear the facts as they come out on stand as well, on the stand. So they are very fast and furious for the assistant district attorney trying those cases. They are not going to have as much time to prepare as you would think. Sometimes it's 2 minutes before the trial starts. Sometimes it may be over lunch. So this is what you can do. If you are a police officer, if you are a civilian witness, it's going to be the same. What can you do to help? If you're a police officer, bring a copy of your police report with you for the ADA so that they have something to look at. So they know the facts and they have something to bring. Bring a copy of your report. If you only have a few seconds, then tell the ADA important facts or features of the case prior to trial. Just mention it to them before it starts so that they know what to bring out. If you are an officer, bring the evidence to trial with you. You can't try a case if you don't have the evidence to put in with you. So bring it, bring the evidence to court when you're coming in. And if you know this is going to be a serious case and it's something you need to talk about, it's going to be up to you a couple days before the court date to contact the district court DA, set up a time to meet with them and discuss it. They can make time, but they're not going to know what cases they have on generally, except for one day, maybe one evening right in the future before their case comes to trial. Superior court is different. We are going to have multiple administrative settings once the cases come back from the grand jury. To touch on that a little bit, be prepared with the facts of your case to answer for the grand jury. I've just indicted a case where my officer brought a video to show to the grand jurors. So if you're a law enforcement officer, bring the video, show it to the grand jury so that they have something else to come back with that true bill for. Show them what you have so that we can do this. Again, the defendant, their first setting, they're going to be advised to write to an attorney or an attorney going to appear. In my county, we have a first setting and a second setting. Your first setting offer tends to be better. I got first setting and first setting. So your second setting tends to be, your second setting plea offer tends to be a little worse. It's not as sweet a deal. And then again, we're going to have those endless continuances until we can finally get to trial.
Jessica, while we're talking about trial, actually, Kaylee Tabor submitted a probable cause hearing. So is that a mechanism for preserving testimony on an as needed basis from time to time?
You can. In my county, we don't do as many probable cause hearings. We find them to be more fishing expeditions for the defense. And if you have not prepared, probable cause hearings are going to be done in the district court. So again, Superior Court, a lot more preparation, district court usually on the fly. And if something misses, or if that testimony tends to be different in district court versus Superior Court, that's something the defense attorney is going to use to come out against your defendant or your victim. They're going to use it to say that they're lying. They're going to use it to say something. So if you think that there's going to be an issue where your victim may not be around, then that may be a good avenue. If it's something that you can have the time and actually take the effort to prepare slowly, perhaps as well. But again, in probable cause, the standard is going to be different than an actual trial. So the questions you choose to ask in a probable cause hearing may be more general because the standard is not going to be as high. And if you're doing that and it is recorded, then you need to make sure that you're considering that for the trial down the road. So in my county, we generally skip the probable cause. We'll just indict somebody and go to trial, but different counties do things in a different way. And that is one particular option that you could use.
Is that something that the police officer should specifically bring to your attention before they show up in court, that that's what they're hoping to accomplish?
If it's gonna be a probable cause hearing, usually you're gonna have to have a time set for it, and you're also gonna have multiple witnesses. So that was something that would need to be scheduled ahead of time. It again probably wouldn't be something that was done on the fly. But if your officer thinks that your victim has some health issues and or some other reason they may not be able to testify later, then that's the kind of thing that your officer should reach out for and let you know as soon as possible so that you can prepare for that when it comes and you can put things in a faster posture.
Thank you, Jessica.
Okay. So sadly, as we've been talking, the wheels of justice move very, very slowly. And with COVID times right now, they're moving even more slowly. In my county, we didn't have a criminal trial in all of 2020. So we haven't started trials. We're going to start them in July in 2021. So as you can see, very, very slowly. This is what I do. Then when things come time for trials, this is what I start preparing for. I'm going to meet with my officers. I may go out to the crime scene and take a look at it for myself. I'm going to go review all of the evidence. I'm going to meet with some witnesses. I'm going to think about what types of questions I need for this particular jury. What types of questions do I need for my witnesses? When I meet with a new officer who's never testified before, sometimes, not all the time, I will go through and I will write out most of my questions. And I tell them, this is not a script. I'm not going by this. I may vary from it. I might not ask you all these questions, but I give it to them so they can review it, so they can know a little bit more as to what's coming. That's something I like to do for my officers who've never testified before. When I write out these questions, it also helps me organize my trial plan, how I want to put things in, how I'm going to get my evidence in, who I'm going to call, in what order. Also, oftentimes they're going to be what are called pretrial motions. That's going to be something filed by the defense or filed by myself. And I have to research the law and prepare for those.
Jessica, before you move on, Lori Gallagher asked the question, you've spoken in terms of police officers. How often do you actually work with banks who have done their own internal investigations? And is there a statewide form that you're aware of that allows adult protective services to obtain financial records from banks?
I don't know if there's a statewide form. I do know our APS officers are able to get financial records, and they can get them in a different way than my police officers can. And a lot of times in our task force, one of the things they'll be discussing back and forth is who has the better ability to get these particular records. And so I know that they do that. I don't know of a statewide form. I do meet with all of my witnesses. So if I have something that is going to be going to trial, then I will meet with the bank representative, the bank investigator. And I have done that multiple times before they come in and try a case. I usually will not talk with them until it becomes close to that trial time. My investigator from the law enforcement agency, the one who's going to be taking out the charges, will discuss them and oftentimes get their reports. And so I'm reading it through the report of my law enforcement officer. But I meet with every type of witness before anything goes to trial. Anybody who's going to be on that stand, that's the person that I'm talking with. So oftentimes it has been bank investigators.
Thank you, Jessica.
Sure. The victim in trial is going to have some specific needs, especially in elder abuse cases. We had a case here where a gentleman came and it was just a plea, it wasn't a trial, but he came on his own and he had been hurt in the assault that had happened and he was injured already. And then he came in and he slipped on the floor of the lobby of outside the courtroom and he broke his hip and had to go to the hospital and wasn't present for the plea. I don't like for that to happen. That fortunately wasn't my victim. I want somebody with my victims when they come. I've had some victims that don't have the ability to get to the courthouse or they're scared. And so my officers go and will pick them up. And my officer will take them through the back hallways of the courthouse so they don't have to be in there where they may run into the defendant or the defendant's family. We will keep them in my office or in a witness waiting room where they can be secure and safe. So be prepared to give somebody a ride to court. It's going to help a lot with their confidence and the ability to be there. I've had a case where oftentimes lawyers will ask for the witnesses to be sequestered, which means they only one witness in the courtroom at the time. But if I've got an elderly victim, I had one case where it was an older couple whose house had been burglarized twice in one night by the same people. And they were terrified and they needed somebody to sit in the courtroom with them. So they might need a support personnel. I might have to fight with the judge about that and fight to keep somebody in there with them so they can sit and be supported throughout the trial. We might need to think about preparing to have somebody sit with them. Somebody might have to take off of work. They might have to do something like that to be there. My officers, they're going to have to just be ready to be in court all day. And it sucks for them sometimes, but they've all been really good at understanding that this case, this is what we need. And another consideration for older adults oftentimes is sometimes people are sharper at different times of the day. And I need you to tell me that. I need you to tell me that they're good in the afternoon or that they're really good in the morning or different things like that so that I can plan my trial around the time to have them testify when they are the sharpest. So let me know those things. I'm going to have met with people, but I'm not going to know them like you're going to have known them. So I need you to let me know.
Jessica, tell us about victim witness personnel. Do you have those in your office, and how do they help during
we do, but they're not running out and picking up people. They generally will escort people in and out of the courtroom. They'll have people, they'll show them where the rooms will be. They are going to contact and talk with people prior to trial. This is what our victim witnesses do. They're basically a touchstone of the DA's office for our witnesses to talk with. And but they're not going to sit with somebody. They may sit with them in the trial if nobody else is available. They could sit with someone, but most of the time they're running around doing getting more witnesses, calling the next person, things like that. Jury selection. I have learned that in my cases, I always thought that care providers would be great jurors. I've learned that they're not. They tend to be more sympathetic to the defendant. I want somebody who's not a care provider for an older adult, generally. So you have to think about what type of person for what case you have and what kind of things that you want from them. I want to touch on one thing real fast. My APS people who are here, y'all are so nice. You're so nice. And trial is not the time to be nice. Do not minimize what happened. do not try to be nice on the stand. I'm not saying be rude or mean, but you need to say what happened. If you almost threw up when you walked in a room because of the smell, I need you to mention that fact on the stand when I ask you about it. I need you to not gloss it over and try to not embarrass the defendants, because oftentimes you'll have relationships with the defendants as well. When things come to trial, it is time to be brutally honest with what happened. Don't tell me you almost threw up, and then when you get on the stand, and I've asked you, you don't mention that. So don't minimize. That's what I want y'all. Y'all are so nice, but when it comes time to testifying, do not minimize what happened. I need you to be honest about what you saw, sometimes brutally honest. Okay, this is what happens in a trial. I'm going to put on my evidence, then I'm going to rest. The defendant always makes a motion to dismiss at the close of the state's evidence, and then they can put on their evidence, and then I can rebut their evidence, and they can talk about my rebuttal. And then after all of the evidence has been put on, the defense again is going to make a motion to dismiss. Then we're going to talk together with the judge about what charges that the jury is going to get to hear. The jury is going to get the case, and then they're going to come back with a verdict. So again, when you ask what can officers do, this is us, this is the DAs. We're going to look confident, but we are nervous and we are stressed out. So if you can be early to court and be prepared, be prepared, be prepared. If it's district court, bring a copy of your case. While you're sitting there waiting your turn, flip through your report, refresh your recollection. Don't just waste your time while you're in there. Be prepared, be ready to answer questions. Get there early. Don't stress me out anymore by having a judge yell at me because they're ready to go and you are not sitting in the courtroom. If the jury comes back with a verdict of guilty, we're going to have a sentencing hearing. Again, that's when, I decide what is justice. What sentence am I looking at here? Am I going to do aggravating factors or mitigating factors? Something to make their sentence worse, something to make their sentence lighter. And then we have a structured sentencing chart. I didn't put a copy of it in there, but there's a legitimate chart that I'm bound by. Somebody's going to be sentenced to a specific sentence based on their prior criminal record and what level felony that they're charged with or what level misdemeanor. If they get an active sentence, then, or these are the outcomes, they're going to have a sentence imposed by the judge. They could get active time, probation, restitution. If they get probation, again, if these people don't have the ability to give money, you're not going to get any money. So again, it's what I tell my parents, expect nothing. If you get something, you'll be happy, but expect that you're not going to get anything. Oftentimes, most of my defendants do not have the ability. They've spent up your money, whether it's on drugs, vacations, anything. Restitution is difficult to get oftentimes. In probation, someone may be ordered to community service. They can order no contact with the victim if I want that. Oftentimes I've seen the judge order that they get their GED if they don't have a high school diploma. They'll be ordered into drug treatment. They'll be ordered to stay basically out of trouble. There may be any other number of special conditions that I can ask for to be asked about probation. I can order that they not go on about the property or not even be in the same block as the victim. There's just all kinds of different things we can ask for in probation. And so you would think we're done because the trial is done, the sentence is given. It's not, we're not done yet. For one thing, oftentimes people don't comply with their probation. They end up having probation violations, and then we have to fight with them all over again because they didn't do what they were supposed to do the first time to try to stay out of prison. But this is what happens after a trial. So you think the trial is over, it is not over. The defendant may appeal the case. It's going to go to the Court of Appeals. It may come back. It may go forward on to the North Carolina Supreme Court. It may come back. It could theoretically go up to the U.S. Supreme Court, and it may come back. And if it goes to U.S. Supreme Court, it is going to come back like 10 years later than what has happened, or 9 years later, any number of years later. Even with the North Carolina Supreme Court, it may be like 2 years later after our trial that it's going to come back. If it comes back, we may end up having to try it again. There's another thing that's called a motion for appropriate relief after something has been done. Somebody's entered a sentence, somebody's entered a plea, then they can come back and try to reopen the case. And that motion for appropriate relief, they're going to say that they didn't have an adequate representation by a lawyer, or new evidence has come up. or something has happened now that's going to be a reason that this whole case should be opened up again. And this could be years and years later. We have an innocence commission here in North Carolina, and they are reviewing capital murder cases, and they may be 20 years old and they're being reopened. So these things never end. They never end. They are, you would think after trial that it's over. It is never over. Gratefully, sometimes it can bring closure to my victims, but you always have to prepare people and know the possibility that this may come back. So what can you do? What can you do to help? Just report elder abuse if you see it. Just it is our duty to report it. Cooperate. People don't like to come to court. They don't like to take time out of their schedules. They don't want to come here and meet with me. Cooperation is actually really difficult for people. Doctors oftentimes have busy practices and it's difficult for them to come. Be prepared when you do come, and then don't give up. Keep your notes. If you're law enforcement officers, keep your notes. If it's a case you think may be coming back, keep your notes. It may come back. And I think we're just about at my hour, and this is my contact information. I'm happy to talk with anybody in the future if something should come up. And I don't know, I'm happy to answer any questions if anybody has anything else.
Jessica, we have until 11, and actually there are some questions. There is some legislation that is pending. Can you talk to our group about that and its where it fits in the overall scheme of things should it pass?
Sure. I brought up, I don't know if this will show up over here. Is it showing up now?
It's only showing up a little bit. Yeah.
I don't know if I can make it close. I don't know if I can make it close. This is our statute that is being proposed to be changed. There's, again, like I said, there's several statutes that may come up with elder abuse prosecution. This is just one of them. This is the one that is titled specifically.
You make that full screen.
Let's see.
No.
I don't know. It's from this weird website, so I don't know if I can do that. No. If I was more computer savvy, probably yes. And I apologize for that because I am not computer savvy. But this is the statute. It is the elder abuse abuse and neglect statute. And there is a proposed law that has passed the House, House Bill 699 right now. And it's the same law. What they want to do is to increase the punishment though. So this is so annoying. I don't see an ability to grab it and make it bigger either. I would do that. You can see on the proposed law, then the dashes are what they've crossed out. And so that's the change in this law that they're asking for. And what they're asking for here is for an increase in the punishment. So it's just so annoying, and I apologize for that. If someone is guilty of abuse, you can see the elements here. And then if they're found guilty, that currently is a class F felony, and they want to raise it to a class E felony. And if it's not a serious injury that they suffer, then it is a class H felony. To put that in perspective, a class H is a breaking and entering is a class H, so somebody breaks in your house. A class G that they want to change it to is possession of firearm by felon. Common law robbery is a G. They want to raise, if you've suffered a serious injury, they want to raise it from an F. The sentencing chart goes from A as the highest, which would be capital murder offense, and all the way down to I, which is the lowest level felony, which you can see here. There is an I here under the neglect part of the statute. That's the lowest level felony. If you have like one rock of crack cocaine, that's an I felony, and they want to raise this to an H. Again, if it's neglect and somebody suffered serious injury, it's currently a G, and they want to raise that to an F. you can look in your handy sentencing chart, and if somebody doesn't have a record for a G mitigated right now, the absolute minimum that they will do is 8 months to 19 months if they have no record. The H is 4 months to 14 months. And an I, you have to get some type of community sentence if you don't have a record at all. So you can see if somebody is found guilty here of the neglect, but they haven't suffered a serious injury, then it's going to be just that little slap on the wrist where they're going to have to get mandatory community sentencing, the mandatory probation, and it's a 3-month sentence if activated. So that's why people want this particular charge increased. I think it would be a good thing to increase this. It is heartbreaking to see someone that has been so neglected that their skin has ripped off when somebody pulls a sheet off of them because it's attached to them from the urine and the feces that's there in the bed with them. And that would be a serious injury, and even then it's currently just a G. So it breaks your heart when you see things like that. And so I think a harsher punishment for that would be great. Fortunately, we don't see that many cases of domestic abuse or neglect. Most of the time, it's financial, which is just as heartbreaking, because when somebody's worked their whole life to be able to prepare to live out the rest of their life in the manner and the means that they had planned on, and somebody's wiped out their life savings, and they oftentimes may have to go back and get a job now, and then they have been retired, and it's hard to get jobs, and that one would not necessarily be covered here under the abuse and neglect. This one goes to physical abuse. So if somebody wanted to raise that, I'd be okay with that too.
There's a question here or a comment about financial exploitation. And it's where the individuals take advantage of the assets that are for somebody who is disabled. Now, even if there's not a financial exploitation law expressly addressing, in the instance here, it's for a disabled child, where the guardians use those or deplete those assets for their own purposes. Aren't there general statutes on the book that could enable you to prosecute such a case if the facts supported it?
It's the same, actually. If you read that particular statute, it's older adult or disabled adult. So they are actually covered under the same statute for that type of exploitation, financial exploitation. So they can be a disabled adult or an older adult. And I can't remember off the top of my head right now what the age in that statute is listed at. We have a couple different statutes that list the definition of an older adult as one of them 60, one of them 65, and I can't remember which one that is. But if it meets the age requirements, then of an older adult, it would also apply.
If it doesn't meet the age requirements, though, if, for instance, say it's a child or somebody who simply just doesn't meet the age requirement, are there general statutes that still might be brought to bear?
Sure. We have the catch-all that I use all the time is obtaining property by false pretense, and then just larceny, like you stole something. If you stole over $100,000, then it's a very high felony. But if you've stolen anybody's money, then you can be charged with larceny. So it doesn't have to be. That's just the most general one that we have.
Even guardians, those entrusted?
Guardians are going to be, they could also fall under embezzlement because they have been entrusted specifically. And obtaining property by false pretense and embezzlement are almost the same thing. The difference is that under embezzlement, you have to prove that somebody has been entrusted as a specific element as well. So it's the punishments are the same. The wording is different, but the punishments are the same. So the outcome would be the same.
Fabulous. Jessica, thank you so very, very much. We appreciate you
having me.
Yeah, helping us all out. We have 80 seconds. Anybody have a quick question they'd like to share with Jessica.
I'll give a shout out to Jennifer Waddell, my friend who's on here watching me. I'll hear about it later.
Yes, excellent presentation. I very much second John Marin's comment. Excellent presentation. Thank you, Jessica.
Thank you. Thank you.
Everybody will be shifted back into the main room for our lunch break. You do not have to leave. Next is lunch on the agenda for everybody. Please leave your computer on. Don't leave the conference.
Slides playing, thanking the sponsors and all the organizations and agencies that have become a part of this conference. We want to show the thank you for them and let you see their information that you may be able to reach out to some. Also, the partnerships information is going to be on there about joining. We would love to have you all to become a member. It's probably the cheapest membership around. So we hope that it will encourage you guys to join us as well. We even have some folks, some board positions that you may be interested in, and we do have a great group to work with. So again, while you're doing your lunch, we will have some slides playing with some music. So if you don't want to hear the music, you may want to turn down your speakers. If you are eating at your desk, maybe you may enjoy the music. So that's great to know. Okay. And it looks like everyone is back from break. So what we're going to do is we're going to go ahead and Laura Slawback, if we're going to start the slideshow for us, and we'll all hear the music. So again, turn down your speakers if you don't want to hear the music during their lunch. But when you come back at 1 o'clock, make sure you click the join button on your screen. So we'll see you all back at 1 o'clock. Just want to remind folks that we're at lunch now from 12 to 1. When you come back from lunch, please make sure you click the join button on your screen for your next breakout session. We will get the slides up and going here in just a second with the sound. So if you don't want to hear the sound as we're going to lunch or while you're at your desk, you may want to just turn your volume down and we'll have the slides up and going for you. So enjoy your lunch. And again, don't log out, just stay involved, and we'll have the slides going with some music there for you. Welcome back, everyone, from lunch. I hope you had a great time, and I hope you enjoyed the slideshows. Again, some of you may have turned down your speakers during the lunch break, as I suggested, so the music wouldn't be so loud. So now you may want to turn those speakers back up. As I know it's 12:53, we're getting closer to the 1 o'clock hour. So what Allison is going to do is she's going to start moving everyone to your breakout room. So just a reminder, when you go to the breakout sessions, you'll want to click the join box on your screen. It should come up in a pop-up on your top, or if you go to the bottom, you should hover and you see the breakout rooms, and you should select